The Medicaid EPSDT provisions are designed to furnish children and youth with comprehensive care, from well child checkups to the care and services needed to correct or ameliorate illnesses or disabling conditions. However, problems can come up when requesting specialized health care needs for your child. Problems can include a denial of service or equipment that is important for your child. Other problems could include billing issues, trouble finding an appropriate provider, or communication issues. When an agency or managed care organization makes a decision about your child's Medicaid services that you disagree with, you generally have the right to appeal the decision. How do I appeal? The appeal process depends on whether your disagreement is with a managed care organization, sometimes called MCO, or another agency that is not an MCO. If a managed care organization made the decision about your child's services, you generally have to appeal through your managed care organization first before you can appeal using the state fair hearing process. If another agency that is not managed care organization, like Iowa Medicaid Enterprise, made the decision, you must appeal using the state fair hearing process. How do I appeal a decision made by a managed care plan? When an MCO makes an adverse benefit determination, for example, denying or reducing your service, the MCO must tell you in writing and tell you how to appeal. You also have the right to ask for an expedited appeal if your child's physical and mental health or their ability to function would be seriously at risk. You also have the right to ask your MCO for help with filing an appeal. The written notice will include reason for the denial, right to file an appeal and request state fair hearing if applicable, procedures for the appeal, right to continuation of benefits pending resolution of appeal. Are there deadlines for filing an appeal with my managed care plan? Yes. Look for a date on the notice you got in the mail. You must file an appeal within 60 days from the mailing date of your notice. However, there is a shorter deadline that you need to follow if your child's services are being reduced and you want those services to continue at the current level during your appeal. This is called continuation of benefits. In order to receive a continuation of benefits, you must appeal within 10 days from the mailing date on your notice or before the reduction takes effect, whichever is later. You also have to file the appeal before your current authorization period has expired. For example, the period of time your MCO approved nursing services. If you do this, your child's services must be kept at their current level until the MCO makes a decision, called an appeal resolution. What are my rights if I do not receive written notice in the mail? If you do not receive written notice, for example, if someone tells you over the phone your child's services will be reduced, you can file an appeal with the MCO. You could handle this in one of several ways. You could file an appeal. You could ask the MCO to put the decision in writing before you appeal. You could send the MCO a letter documenting what you were told and when, and then file an appeal. In fact, if you do not receive written notice, this may allow you to skip the managed care organization appeal process and go straight to the state fair hearing process instead. If you have questions about what you should do, you can call Disability Rights Iowa for help. What are my rights if I disagree with the MCO's appeal resolution? If you disagree with the appeal resolution, you can request a state fair hearing. This request must be made within 120 days of the date on the notice of the MCO's appeal resolution decision. What is a state fair hearing? This is an administrative hearing where both you and the MCO or Medicaid agency can present your arguments. You can gather and submit your own documents that you want the hearing officers to review. This could include letters from your doctors or other medical records and assessments. For example, you may need a letter from your doctor to explain why the service or equipment is medically necessary for the child. You also have the right to have witnesses. Witnesses are people who attend the state fair hearing to provide helpful information for your appeal. This could include family members, doctors, or other medical providers, therapists, case managers, other advocates, etc. The administrative law judge will then decide if the denial or action taken was correct. You will receive a written decision in the mail sometime after the hearing. For more videos on EPSDT and/or assistance with appealing medical decisions, visit our website at www.driowa.org or call Disability Rights Iowa at 800-779-2502.